Hi, everybody. I'm Larry Verbit. I'm the chairman of the entertainment law section of the Beverly Hills Bar Association, and we want to welcome you to the third of three of our panels this year on talking about what's occurred over the last year. We're going to deal primarily with production and transactional issues that we've experienced in this period. First, I want to tell you that we welcome everybody to participate in the entertainment law section. We have our meetings on the first Wednesday of the month at 8:30 a.m., all via Zoom at this point. So we welcome you to join us. We want to tell you about two upcoming events. On April 5th, we have a new program we just added called Art and Music and the NFT Boom: What and How Intellectual Property Rights Are Implicated. Demand for non-fungible tokens are at an all-time high. So join us for this exciting panel, which will feature a special appearance by deadmau 5. On April 21st, the entertainment law section is partnering with the bankruptcy section for the program addressing IP rights in bankruptcy, including panelists involved in the Weinstein Company bankruptcy. I want to welcome and introduce our panelists today. They are all rather modest and gave pretty short bios, so I'm going to quickly run through them, maybe cut through it a little bit. First, Cathy Sadler from Universal Studios Group. Cathy is Senior VP of Legal Affairs for Universal Studios Group. She's responsible for licensing and co-production agreements for all of USG, including Universal Content Productions and Universal Television. And she handles all aspects of scripted television development and production. Prior to working in legal affairs, she was VP and rights counsel for NBCU's Intellectual Property Group. Next, we have Kobie Connor. Kobie serves as the Director of Business Legal Affairs for Original Independent Films at Netflix. Prior to joining Netflix, Kobie spent over a decade at 20th Century Fox and Fox Searchlight Pictures in business affairs leadership roles. Kobie also spent time as legal counsel at Walt Disney and Paramount. After graduating from Yale Law School, Kobie was an associate at the law firm of Morrison & Foerster and served as law clerk on the U.S. District Court for the Central District of California. Next, we have Jody Zucker, whose Warner Brothers Television Group is Executive Vice President, Legal Affairs, the world's leading supplier of television programming. Jody and his team provide legal counsel for the development of production and licensing of all scripted and unscripted television programming produced by Warner Brothers for network, cable, premium pay, streaming outlets, including The Flight Attendant, Ted Lasso, The Bachelor, Young Sheldon, Riverdale, and numerous other popular television programs. What I left out, you can look at the materials we gave you, and you can fill in their bios as well as my own. Give me 1 second here, because oh, here we go. We recommend to the people participating today that you review the materials from the litigation panel, as it offers a great deal of background on cases impacting the industry over the last year. The goal of this panel is to address the practicality of dealing with production and related agreements in the era of COVID and the rise of OTT and various other factors that have impacted the way we do business and deliver programming and films to the public. There is quite a lot we could cover, but due to time constraints, we'll only be able to focus on a few items. We're going to proceed in a conversational format. We're going to hold off taking questions during the discussion, and we'll save time at the end. You can pose your questions in the Q&A at the bottom of your screen, and we'll review them as we get towards the end. So for the panel, I'm going to say, let's look back at March 13, 2020 and the start of the lockdown, how that impacted all the projects you were working on and what stages. First, let's discuss force majeure. Did you address the force majeure aspect of any agreements with respect to closing down? And if so, how did that play out? And did that force you to consider modifying your agreements to expand force majeure impact to productions and related agreements? So I'm going to ask Jody to start off on that.
Yeah, thank you, Larry, because there's something I think is worth pointing out, and that I'm glad we're covering this topic because it's one that'll endure. It's not just COVID related. The first thing everybody asked almost instantly was, "Are you declaring a force majeure?" And it really loses sight of the legal intricacies of what this means. So to kind of channel my inner Fauci, one does not declare a force majeure. A force majeure declares itself, almost by definition. Force majeure event is something we don't control. And so the real question for the lawyers, and since we're all lawyers, I think it's appropriate that we lead this question, is what does that mean with respect to the contracts we have in light of the shows shutting down as a result of the force majeure event? What we're really doing isn't declaring force majeure, it's taking advantage of what rights we have under the force majeure provisions of both the guild agreements, which really impacted what we did, and under the personal services agreements of the people who are working on the shows that got shut down. The shows were all shut down. I don't think any of us kept anything running in March. We got some reality shows back up and running, but the shows were all shut down, period. There was no way to keep them up and running. So the force majeure event occurred, whether you declared it or not. And the first thing that we had to do was then analyze, how are we going to act within our rights in order to try to stem what became a very quick flow of lost earnings as these shows languished. So that was really our first step. And I think probably similar to the others, but I'll leave it to them to talk about their nuances.
Kobie, can you add anything from how Netflix approached?
Yeah, and I think to follow up on what Jody was saying, I think it also a major impact was really where you were in production, because it varied. Like some projects were midway through, some projects were almost done, some were starting. So like to the extent that you didn't have to call a force majeure event on one project didn't mean you didn't call it on all projects. So it could vary from project to project depending on where they were in the production phase. Some we just shifted because we were in prep, but we hadn't started anything. Others you had to declare force majeure because otherwise you might lose folks, or you to the point, declaring it was not the case. You couldn't shoot. Like when you were in particular jurisdictions and particular territories, you were shut down. So you didn't have a choice in the matter. So you had to declare. So those are the things that we had to look into. We had to look at our contractual language to see kind of what protections we had or didn't have. And one point was really like, if you suspended and extended, did you have to do it for everyone versus just some people or not? So these were all the things you had to take into consideration. And in beyond just production, you looked at development deals too, because particularly rights deals, because you had option periods that you couldn't effectively use during this time if you wanted to start, if you wanted to purchase. So we kind of looked at whether or not we would be extending rights deals because of a force majeure, or at least calling force majeure to kind of toll the option periods. And one of the things that we determined, at least on that in that aspect, is if we really weren't in a position to go into production, or we weren't close to production, then we just let the option period continue to run. If it was something that truly was impacted by COVID, then we could potentially make a different determination. So those are some of the things that we thought about in the process.
One of the things I'd like to point out, because Kobie makes a good point, is where were you? And so because we produce for all kinds of different outlets, we had a lot of broadcast shows that by March were pretty much near the ends of their orders. They had produced 18, 19, 20 episodes. We had fulfilled everybody's guarantees, and we just weren't going to get back up to finish the season. But those shows shut down, and there really was no need to use force majeure provisions on any of them. Other ones were in prep, much easier to shut down. Then there were the few that were in mid-production where you hadn't met minimum guarantees. And this is really important because I know a lot of the lawyers out there who are listening have grappled with this age-old request for a give in the force majeure provisions of no selective enforcement. And if anything proves how important it is for us to have that flexibility, this was it. Because you didn't need to exercise it with regard to everybody. Certainly with regard to different categories of people, your ability and the cost of doing so varies tremendously. Suspending a SAG actor under the provisions of the SAG agreement is limited and costly. Directors under the DJ agreement have a tie to the actors. Writers are governed by their own provisions, and they are the ones most likely to have been working already if you weren't in production. So it's really important that the studios have the flexibility to suspend where they needed to and not where they didn't.
Cathy, anything different over at your facility, or?
It was a lot of the same thing. I mean, it was really like, where were we in the process? We had a few shows where we had mostly finished. We'd finished up, let's say, 18 out of the 20 episodes or whatever. And then we had to make the decision, whether we were going to just stop there and roll the episodes over. If we had scripts written, for instance, maybe we would roll those scripts over into the next season and looking at minimum guarantees and things like that and making sure that we were squared away there. We actually were in the middle of shooting some pilots, and I think we had a couple of pilots that maybe got like a day or two of shooting before everything shut down. And so, we had to look at, and then I think we had some where we just were in prep and we hadn't done anything. And so there was a lot of looking at like our options on talent, particularly on screen talent, and whether we could hold those, whether we wanted to hold those and how we would do that. And being careful and mindful, as Jody mentioned, about the guild implications, if you suspend somebody or you don't, for I think it's 5 weeks, and then they can terminate their agreement under the guild provisions. So keeping that in mind. I will just say the other thing we had to deal with was our license agreements. We are networks and studio, and so we had to look at both inbound and outbound, commitments, obligations. On the inbound side, I think it was a lot of, what does the force majeure provision say? And, evaluating that. And I think we learned a lot about what maybe our provisions should be saying going forward, because, to Jody's point, like, I don't really think we've ever really experienced this before. We've obviously dealt with strikes, but I don't really think we've had the pandemic. And just sort of learning that those provisions, I think, need to be more buttoned down as to what a force majeure experience is. Does it necessarily have to be foreseeable? Can it include pandemic? You need to include that specifically. I think you probably do. I think we've actually looked at, in some circumstances, addressing COVID separately if it's something that we think was going to be impacted, because now it's a foreseeable event. So we actually want to bring it out and talk about what's going to happen, because this is ongoing and we don't know how long it's going to be ongoing. And I think we've also learned some lessons around, it isn't necessarily sufficient just to say that the force majeure event prevents performance. You can have performance, but can have it really be materially impacted. I'm thinking of like some live specials where, we could still have the special, but everybody's going to be at home on a Zoom, and there's no red carpet, or there's no other, kind of bells and whistles that go with those live events. Right. So anyway, I think there's just been a lot of thought and a lot of,
well, that kind of brings me to the next question, but I just want to add one thing. I had an interesting experience where I had a 20 episode series moving into a studio on the 17th of March. And the fight we had with the studio was a force majeure clause, which they would not accept. And we got to the point where we didn't have a signed contract the Friday before, when we just closed everything down. So, but that's an interesting item, because Jay Doherty actually, in our Q&A, and I'm not going to answer questions now, mentioned that what about the common law aspect of a force majeure? But with respect to the force majeure, that you mentioned about language, have you been looking at language now and taking it into consideration and modifying your clauses? Adding pandemic, epidemic, public health, specificity versus such as. Have you taken any of those steps?
I have to say, this kind of trails off what Cathy was saying. We actually had a pretty good provision, and it did talk about materially hampering production, which I think is a very important aspect of this, because you can't do it at any cost, and it's got to be something that's sellable. But we had a provision that I think pretty adequately covered it. The more important thing right now and for the foreseeable future that I think all the practitioners out there should understand is something else Cathy said, which is it's now foreseeable. Specifically, COVID-19 is foreseeable, and foreseeable to be a problem as we surge and pull back, and hopefully this will be the end of it. But there could be a new strain, which would be a reoccurrence of the same force majeure event. Now, in some cases, we actually had language that talked about how we would only suspend once per force majeure. However, we could suspend again if there was a reoccurrence. Again, pretty good foresight. We argued over it for years. It became important here. But right now, we're not only beefing up the provision itself, for new contracts that we've entered into over the last year, we have a specific provision, as Cathy mentioned, about COVID-19, saying you understand that you are entering this agreement at a time when we are in the midst of an ongoing pandemic. And I think it's important for everybody to acknowledge that going in. There's a lot of risk being taken by the studios here. I know I'm speaking from a studio perspective, but I think everybody's got to acknowledge that there's going to be some risk on the talent side as well, that these things are going to get subverted by the pandemic.
Yeah, you mentioned that the one thing I want to remind everybody, these are your personal opinions and not official comments from your employers. Okay, let's keep moving on. As the lockdown continued and you started ramping up, has there been any impact from the talent reps regarding additional pay, hazard precautions, any things of those natures that, specific to the situation we've experienced over the last year?
I think, what we expected, the first thing that kind of came up, particularly with a lot of talent, is travel. And wanting to not, because look, most, people weren't going to airports, like if you wanted to get them there were a lot of requests about private travel and things of that nature that would come up. There were a lot of issues about like how you were going to address kind of like the safety of it all, whether it's going to be a bubble where it was going to be, once you're in, you're in and you couldn't leave, whether they could bring their families or not. These are kind of real life implications that we had to factor in. And if you weren't going to do a bubble, what was the testing situation going to be like? Like who could have access to different parts of the set at any given time? So it was a lot of these issues came up, and then you had to factor in territory. When I say territory, I mean country requirements. Were you required to quarantine for X amount of days before you could come in? And things of that nature. These are things that were out of our control, but we had to factor in to the deal making process. Was there additional pay for quarantine period or not? So these things kind of had to be addressed on a really kind of, quite frankly, a case by case basis, because one perspective didn't, or one approach didn't apply to each circumstance, because every territory was a little bit different. Every production was a little bit different too. So you had to be mindful of that and be flexible.
Any other experiences with talent demands or anything of that nature?
We had to travel, as Kobie brought up, was really, really difficult. We shoot a lot of shows in Canada. They had a quarantine requirement. And when you put that together with our, traditional December break, it didn't really give them much of a time for a break, because if they left, they had a quarantine when they came back. So they really were kind of, I don't think some of the people, there's been some quotes out there about how they felt like they were being held prisoner. I'd like them to spend a night in prison before they make that comparison again. The truth is that they were somewhat limited, or really quite limited, in their ability to move about. We also had tremendous problems getting people in, especially from the UK. That we had to get waivers. I mean, our government relations executives have never worked harder and been more effective, frankly, shout out to them, at getting waivers for people to get into the country from Great Britain, at all. Also people want to go to Canada with their families. Right now, Canada's not letting people in unless you have a work permit, but there are certain rules around families traveling with them. I think all of us became more expert at immigration rules than we've ever been because of those limitations. But the talent problems have mostly been surrounding the amount of time they have off, both over this past Christmas break and what will now be a pretty short hiatus probably, during which there will still be rules in effect regarding travel. So that's been the biggest problem. Otherwise, we're trying to just live within the confines of the guild agreements. We've told them we're surpassing whatever your guild requires. So to the extent you want more, you really should talk to your guild. We've gone above and beyond, and there's a reason why we could only agree to so much, because the costs are prohibitive.
Yeah. One of the things I experienced, because I do a lot of, below the line non-guild, when we had to travel to Florida, is they wanted to fly on Delta because Delta doesn't have middle seats that they're filling at the time, whereas other airlines did. So, that was something we faced as well.
We got private jet requests, so good for you.
Well, we did too, especially in the beginning. It was all like private jet requests and the hotel accommodations and the family. So yeah, definitely.
Yeah, but not everybody has your budgets.
No.
Well, and not every request was accommodated, unfortunately. You can't, it's just something that you couldn't afford to do. But it was a lot of requests about family, travel, where they were going to stay, and then the various issues about like quarantine as you went from one territory to the next. And to Jody's and Cathy's point, when you had to travel, like if there was a hiatus, and when you would get back, like in that quarantine as well. So it was a mess. But
yeah, production schedules were really, they were really tough, particularly like you're trying to figure out, you're already having to shoot an extra day or two per episode just because of all the COVID and, safety precautions you have to take. But then what happens about Christmas and Thanksgiving? You have to keep them in Canada, and then you don't necessarily want to have to rebudget another 14-day quarantine period for people coming in and out. So yeah, it was very challenging.
There's also, Larry, there's one point I really want to make to all the talent reps out there. One of the other things that came up with regard to safety, this is with regard to actors, we very much acknowledge are the most at risk. Certainly early on in the process, it was pretty frightening. They had to work without masks. Now, in addition to all of the zones that I think we're all now probably fairly familiar with that sought to keep close contacts to a minimum, one of the problems we have regularly is the desire to know who tested positive when we start to put people out as close contacts. And there's a sense of mistrust that we're not doing our job in an effort just to keep the show running. And that could not be farther from the truth. And I think I speak for all of us. There's no value to us to hide stuff. We need to keep these shows running. And in order to do so, we need to keep safe, but we also have privacy obligations. And the truth is, they have no real reason to know other than this general mistrust that we're not doing it well. I mean, we're not perfect, but we're doing it as well as we can. And we do have obligations to withhold those names when they don't have any need to really know who tested positive. Sometimes it's obvious. The director, is on day 4 and suddenly he's not there anymore. That it was him or somebody close to him and that whole pod leaves. But it is a privacy issue that we can't divulge, and there really is no reason to do it. We have no incentive to lie about it. And generally I will tell you, on our shows within the United States, we don't have any evidence of actual transmission on the set. Our sets have been generally probably the safest place to be other than your own home. So we've been doing a pretty good job, whether it's all by skill or luck or some combination. We seem to have kind of kept it pretty safe.
Yeah, you jumped a little ahead on that, but my experience was we had a showdown as I said, in Florida, and all of a sudden the executive producer and one other person weren't there because they had tested positive, and we paid the lab extra to stay open late that night because we did 2 follow-up tests, and luckily they came out negative. They were false positives, the earlier ones, but everyone on set knew who it was, but of course they kept asking, we couldn't say, and this is jumping ahead a little bit. So let's talk about, a little more in depth the privacy issues and the contract tracing. while we're there, since you raised it, Jody, Cathy, what's your experiences in that at this point?
Well, yeah, I mean, I think, we're definitely caught between two opposing sets of regulations, which is one, we are obligated to keep everybody safe. And then at the same time, we're obviously obligated to keep private information private, and medical information is by its very nature very private. I think the challenges that we had, the way we approached it was transparency. Like, we knew we were going to have to be asking questions about people's health. In some cases, we were, taking temperature and doing that, the clear health screening. And we wanted to let everybody know upfront what we were doing, why we were doing it. I think we were very proactive about minimizing, the bare minimum of information that we needed. And we also were very careful about segregating this information, because it in a way so that it was not part of your normal employment information or anything like that it was kept out of our hands. I think for instance, some of the technology that we use, like the clear health screening, I think actually the only information we got is a green or a red. Red meaning they're not safe, and green they are, but we don't get any, and we're not, and I think also part of that is data retention too. How long do you really need to keep somebody's temperature? I think we can make sure that a lot of this data is not held for a very long time, and how it's held, in a segregated way. So I think all of those things were, top of mind as we were going back to work, and we're going back into production. And I think we had our privacy folks and our safety folks just, had to work overtime on these regulations. But I think a lot of it is, very much transparency, telling people upfront what you're going to be doing, what you're going to be collecting, why you need it, and being very judicious about what you take, and being very, very careful about where you keep it.
You mentioned our discussions, in prep for this, that there were electronic, physical items that people would wear to detect who they came in contact with.
Yeah, there's like the Samsung smartwatches, and there's some other devices. Yeah.
Yeah, there's a fair amount of wearable tech that's come out.
Mm-hmm. And a lot of it is if it's done correctly, it's just proximity with other people. It's not your actual physical location. But the idea is, and I think we've deployed these in some cases, is they kind of go off if you get too close to somebody also wearing a device. So it kind of tries to keep people apart. And then hopefully you can use that data for contract tracing. If you do get a positive, if you do get somebody who is afflicted, then I think you and I were talking about this earlier, Jody, is that the idea is that, well, we don't necessarily know who was in contact with who by name. It's by a number or some other ID, and then you try to do the tracing that way, in a way that's as anonymous as you possibly can.
Kobie, anything very different over at Netflix, or substantially similar?
It's similar, but the one thing I would want to say, because in thinking about all the comments we had, like, how many different hats have we had to wear? From like force majeure to travel agents to like health kind of like consultants,
OSHA specialists,
OSHA specialists, like in this process, and we were able to do this, and not always seamlessly, but we had to learn into it. And it's incredible that that we are where we are now, like, given all the things and how quickly we had to switch gears in this process. It's you want to take a step back and just think about it a little bit too, in that context.
Have any of you experienced situations where you've had a case of COVID? I know that Jody said they've been very lucky, they haven't done much, and my feeling on that is that the protocols that our industry have implemented are probably second only to hospitals. And I remember there was that restaurant that complained about the chute in Van Nuys next to it. But there's, our protocols are really strict and such. But have you had any workers' comp claims? Have you had any sick claims or anything of that nature that you've had to deal with?
Yeah, that was the thing I was mentioning. I mean, we've had plenty of positives, but they're all basically community spread. because people are going home at night. We did, just going back to an earlier thing that Kobie was mentioning, we did pull off a very early production that was completely done within a bubble. It was The Bachelor, which we shot in July, which a lot of kudos to the lawyers who actually did the day-to-day work on that, but everybody was kept out at a resort in Palm Springs, and they were kept in the bubble for the entirety of the shoot. All the other ones, the shows that shoot, especially in areas like downtown Los Angeles, where there was a lot of community infection, people were showing up sick, but we have not yet had a claim that somebody caught it from someone on the set. So far, so good. We've done a good job. Hard to prove, too. I mean, with the way this rolls out, if somebody gets it and then the person they were working with tests positive, you still don't know who got it first. Somebody may have been symptomatic first, but not gotten it first. So it really becomes, it's not a case I'm looking forward to having to defend, but workers' comp should make it a little easier.
Well, basically in California, something like COVID was never covered by workers' comp. It was treated like a cold. But there was an executive order last May by the governor, which I think they've extended till the end of 2021 or 2022, which makes it a rebuttable presumption at this point. If someone claims, it is rebuttable and they have to really prove they, acquired it in the workplace. So let's keep moving along. We're not going to go in depth into COVID protocols because I think there's been a number of programs on that. But we want to, sort of just touch on it, somewhat. And, we have a number of links, a couple links in the materials to the Return to Work Agreement and the LA County Guidelines for Film and Television. But the protocols call for stringent testing, facility scrubbing, on-site health safety managers, and a great deal of new supplies, as well as detailed travel requirements and quarantine related to travel. This all adds cost to the bottom line. In some cases, depending on the size and length of the production, hundreds of thousands of dollars. This means more work for lawyers having to draft specific protocols for the production to enforce and find qualified testing companies and HSMs. Additional equipment to separate workstations, maintaining independent studio zones, to limit personnel interaction and PPE, among other requirements. All this along with coordination with the guilds, which must approve the applicable protocols. Who's paying for all this, and how are these costs now factored into the budgets? In view of the fact that this has added significant amount of work to the production management, legal, and other support personnel, can independent producers include those costs in calculating their fees? If, this is a compound question, and if not, isn't it a reality that they have to spend time and effort, and shouldn't they be participating in that?
Netflix is paying for everything.
Are they, Kobie?
Look, I think, to the extent that there are kind of COVID related costs associated, prevention and testing and things of that nature, that you have to now bake that into budgets. Like that's just, that's unfortunately, that's the cost of doing business until we pass this COVID, situation, this pandemic. That being said, I don't know if I necessarily agree with the producers getting particularly for example, if there's the fee is based on a percentage of the budget. I don't know if it necessarily means because we have to pay more to do testing and things of that nature, that should increase the fee per se. If there's new requirements as a producer that the shoot is longer or this or that, maybe that's a conversation or something that you can consider when you're negotiating, but not necessarily the actual COVID related costs or any costs associated with the shutdown or things of that nature associated with it.
Yeah, my experience has been pretty similar. I mean, I think that, to the extent you're talking about a production going forward and you're talking about costs relating to the production because of COVID, like you said, testing, it is just a cost of doing business now. So generally that is part of the budget and that's paid either by the licensee or the producer, but it's a budgeted cost. I think it is a separate budget item because you're right, it shouldn't factor into things like a fee or a premium if there's a premium on a license fee. I get that. So it's typically a separate cost. I think it's a closer call. You're right. If you have to shut down production because somebody gets sick or you had to shut down production at the beginning of the COVID epidemic when nobody was foreseeing that. Those tend to be individually negotiated, and it tends to be depending on the project and the circumstances and that sort of thing. So yeah, I think it varies. It varies what happens when and the project and the parties involved.
Yeah, our experience was pretty reasonable. You know, when you have like broadcast licensees who aren't paying full cost, tended to be generally open to splitting these overages that nobody anticipated. Full cost licensees like Netflix and others, you know, obviously they wanted to see what those costs were, but they tended to be pretty good about covering all or some of them. I don't know the details. I'm not going to get into them here anyway, but it's definitely a cost that was shared. But, I mean, there's no question that as a studio, it was a big hit to our bottom line. I mean, it was not a good year to be in this business. But you know, fewer things got produced, costs went off the charts. So you know, and it'll hit the profit participants too. For all you talent reps out there, you can expect to see some COVID costs, and they're real because they're pretty high. These protocols that we set up aren't easy to run. They require large amounts of space for distancing. You know, the studio lot, one of the reasons we're not back to work yet in offices, one of many reasons, is that we need all the space at the studio for the actual productions, you know, who have had to stay put rather than going out on location, you know, and have turned various parts of the Warner Brothers lot into various parts of the country. You know, Shameless is shooting Chicago's South Side in the former parking lot that some executives on this call probably parked on. So it's an expensive proposition. Looks like it's going to go through all of next season too, frankly, even with vaccinations.
No, I think the testing part of it at the minimum is going to continue, right? So yeah,
Testing
I think that's
and
right.
PPE, probably
PPE
distancing.
Yeah.
Well, that was
vaccination.
I mean, that was one of the upcoming questions is do you know, how long do you see this going? Well, let me go back 1 second. I want to ask, you know, are the studios vetting any of these companies that are providing these services, or are you just leaving it to the production companies to make sure that they meet certain standards? And then, you know, let's talk about, you know, where you think this is going and how long, and you know, at what point, you know, do you see some air coming up for some air on this? Cathy, you want to start?
Well, as far as vetting, yes. I mean, I think it depends on the studio. I'm a little less worried about Warner Brothers, but no, there is quite a bit of vetting that goes on, and we want to make sure that, you know, everything is compliant, not just with the relevant regulations, but with the guild obligations. And we have a lot of that going on because we do have overseas productions, and so obviously we're wanting to make sure. And we have, you know, issues in other countries because they have different testing mandates or things like that. But then we have the mandates that we have. So there's a lot of careful vetting involved. As far as how long, I mean, I agree with Jody. I think this is going to go until into next year, into 2022. I don't know how far, but I certainly feel like when we're doing development deals or when we're thinking about COVID and who's going to bear costs, we're putting that into things that we know may not go into production in 2020 until 2022, because we're just not sure how long testing is going to be part of this. And I always worry about whether there's going to be another variant. I hope not, but I think it would be pretty short-sighted not to be thinking that this is going to be part of our future for a bit.
No. Yeah. Anybody else want to join in on that? Or
I was going to say, I completely agree. And as you can see, like to assume that this is going to go away by like, and I don't even want to speculate that, you know, a win, because, you know, a few weeks ago, you didn't think Italy was going to shut down again. You know, you didn't think other countries were going to shut down. I mean, we do have like the vaccine out there, but not everyone is getting it in the same way and as quickly as one country or the next. So it's very difficult to guess when we go back to normal. And quite frankly, I don't know what normal is going to look like when we go back to normal. So just bear that in mind.
Right. I think one of the items, related to the last question I had was that the guilds, a number of the guilds require certificate to review the certifications of your health safety manager and other of your COVID teams on site, that they want to sign off on it and make sure they're current and operating. Let's move on at this point and deal with the big elephant that's come up in the last year, which is OTT. Certainly, Kobie, you've been part of that for a long time. Netflix is one of the leaders in that. But now in the last year, we've added HBO Max, Paramount Plus, Disney Plus, NBCU Peacock, Discovery Plus, joining Netflix, Hulu, Amazon, and the other behemoths, while there's also many, many others out there. How has this impacted your deal making? Particularly, I think Jody and Cathy, because you're now, doing it for a lot of platforms. So you may not even know what platform it's going on when you're starting to negotiate a deal because the creatives haven't decided. So how are you approaching that?
Oh, it consumes an awful lot of time. I don't know, Jody, I don't want to jump in if you want to. It consumes a ton of time. I mean, it affects a lot. It affects your rights agreements, right? Your inbound rights agreements, because, I remember, when I first started doing this job and our forms were very much based on a broadcast kind of bite model for options and the seasonality of it. And you can't do that anymore when you're selling everywhere. You're not just selling to a broadcast network, you're selling to potentially everybody. And there's no Nielsen season concept. It affects our format rights agreements in terms of the rights that we get, because we were very much looking at things, traditional studios looking at things like US initial exhibition, but if you're selling to a streamer that's worldwide, then you need rights that are broader. It affects our talent options. We in terms of our ability to pick them up for subsequent seasons, because each of the different platforms has different requirements or different timing structures. And then of course, now that we are both, NBCU is doing its own streaming platform, we have to think about our talent participants and our back end agreements and imputed license fee schedules and how that is going to work in terms of what the financial structure is, what the rates that we want. It takes up a considerable amount of time, at least for me.
Well, I hear that it's taking up time and that it affects it, but how are you addressing it actually in the agreements? I mean, how do you?
Well, I mean, I think it depends on the agreement. I mean, I think now, like we were talking, we've sort of restructured some of our rights agreements so that reversion sort of depends on the platform that we're selling it to. Because if you're selling rights to a streamer and the streamer wants, a holdback on rights for 3 or 5 years, then you need to make sure your rights don't revert earlier than that. So we are changing our forms to deal with that. We're changing our forms in terms of our inbound rights so that we're not just limited to US exhibition when we acquire a foreign format, that we can do initial exhibition somewhere else. And then in terms of the talent participants, my team and I spent a lot of last year drafting new imputed license fee schedules so that we could do the Peacock exploitation, and we have internal arrangements so that we can do things on Peacock, and we're looking at how do we exploit across our platforms, which means changes to our back end and changes to the ILF structure potentially. So.
Yeah, Warner Brothers, we've traditionally been delivering to all kinds of third parties, for the whole 21 years that I've been there. So, Cathy, I can tell you that we've been doing this for a long time and we'll continue to, and so will you. It's a constantly evolving process. But you start to see, our forms are fairly agnostic with regard to platforms. But where the complications come in is with regard to how those platforms order programs. As Cathy was saying, we now have different dates. We don't have the standard broadcast schedule. It used to be actor options were exercisable, by June 15th, or June 31st for the first season, because that made sense in a broadcast model. So we've had to constantly evolve those to try to do a lot of if this, then that. And it started with, here's your fee, but if it's for cable, it'll be some fraction of that'll be negotiated in good faith, but never less than 75%. You wonder what we ended up paying 100% anyway. So a lot of this is kind of figuring out as we go along. With regard to profit participations, the only impact is whether or not you're dealing with yourself, in which case you need an imputed license. If it's with a third party, they have to assume that you're getting the best deal possible. And but judging from everything I've heard from everybody who's ever bought shows from us, we are real scrappy in that regard. I don't think anybody's ever accused us of giving them a bargain. So, I feel pretty comfortable with the profit participation, other than when you're dealing with the CW or HBO Max in my case, where we have imputed license fees. And by the way, Larry, to address your question, those two imputed license fees are built into every deal we do. Whether it's targeted to one of those outlets or not, we have it in all of them so that we're covered. But it's
Same here.
hard.
Same here, because as you know, things change. What you think may initially be going to one outlet suddenly is going somewhere else. So yeah, they're in all of our deals
and
as well.
The order patterns really complicate things too, because you can no longer count on orders over 10 episodes a year. Which has obviously created a lot of consternation, I think somewhat legitimately, by writers who are only working on 10 episodes but not allowed to work on anything else for the year. So we've seen new exclusivity arrangements coming out of the Guild in order to allow them a little more flexibility, which may make sense in this short order world. There's not going to be any more 100 episode parties. It doesn't happen anymore.
And it's not even happening as much on the broadcast side either. The broadcast orders are getting shorter as well. I mean, it's not as much of the case, but certainly all the streaming orders are shorter. And I think you're seeing a kind of a contraction as well on some of them on the broadcast and linear networks too.
Yeah. Okay. So before I want to get into a little bit of the back end, but I want to address something else first. And Jody, I know you're not on the film side, but we have to ask you, about the fact that, all with COVID and theaters closing down, but now reopening, the fact that, at least Warner's has announced, and I'm not sure that it won't happen with other distributors, that they're going to go concurrent on, streamers and theaters and how that's impacting the business. And Kobie, you can weigh in here too, because Netflix has been opening in theatrical too, in connection with their streaming as well, and how that's being addressed both, economically and the impact to the industry and the people who work in the industry on those pictures.
I think
I'm
for
gonna let
us,
Kobie to go with this one. I don't even want to touch it. I read it didn't go over very well with Warner Brothers, but I don't speak for the feature side.
I was gonna say I can't speak for Warner Brothers and how that was rolled out and how people were feeling, just anecdotally, just hearing from other people about that process. I think for Netflix, obviously our core business is streaming. We do some limited theatrical releases. I think because you have like other companies that are now getting into streaming, it's helpful for us as well to kind of, if we want to do kind of a limited theatrical release, maybe that window will open up a little bit more for us, as well as doing whether it be a concurrent release or some limited release and a release on the service thereafter. That's something that we've done in the past and we will continue to do. On a case-by-case basis. So I don't think our strategy changes in that respect. I think, but it is with the other companies getting into the streaming space, it's getting a lot more competitive across the board for content, to work with talent, which is exciting and frustrating at the same time. But I think to be talking about streaming is helpful for all the companies, because that's just another opportunity to get our content to the masses. I don't know if it's always helpful for the exhibitors. We're going to have to figure out, well, the major studios will have to figure out that balance when that happens. But it's an exciting time for the industry, I think.
Okay, before we go to questions, one other subject I want to hit on with regard to streaming, and how are you working on back ends on that? How are they determined? Or are you just bonusing people? And how are you looking at, and now that you're in the streaming business, Cathy, maybe you have something to add to what Kobie can do, and Jody, you're familiar with that, I suspect, as well. So can you weigh in on that? Kobie, you're the first one.
It's, as far as back end and contingent comp, like nothing for us has kind of like changed in these circumstances. It's negotiable. We don't have a performance-based contingent comp, at least on the feature side, we don't. So, it's negotiated kind of like a guaranteed premium, if you will, or a buyout. Some call it a premium, some call it a buyout. And that's been pretty consistent with our processes, and that hasn't changed.
So there's no way to determine the revenue to base a percentage. You're just looking at numbers.
It's a number. It's a negotiated upfront, based on obviously people's, stature, precedent, kind of, and it's a case by case circumstance, a case by case negotiation.
Anything different, Cathy and Jody?
We're always exploring new ways to compensate people. Right now, we're pretty much straight MAGR, modified adjusted gross. And I know there are other models out there that are bonus based. There's an advantage there, I think, because it provides certainty to both sides and reduces one of the principal points of contention that we have with our talent, which is how we calculate the MAG. So it does give certainty in that regard, but then it also caps, much like we're being capped when we produce a show for Netflix. Yes, there's no risk, but our upside is capped. The thing about these bonus structures is, yes, there's certainty, but your upside is capped. So whether or not we end up rolling it out, I think will remains to be seen, but certainly we're always considering it. I'm not sure if it's good for the business or not. We're one of the last places that consistently gives profit participations to our talent. And in a way, I'd like to think it helps to operate to keep the industry honest. Because we're out there trying to make the best third-party deals possible. But when it comes to producing for HBO Max, which is an affiliated entity, it's a harder proposition because we're going to get challenged on it, whether we make the best deal possible or not.
Right.
We're in the same boat. We're always exploring it. I think, like we were saying earlier, this is always evolving, but we're still with an MAGR definition. And then if it's an affiliated entity that gets the initial license, we have an imputed license fee schedule that we include as part of that. It's agreed to. But I think there are pluses and minuses to doing the bonus system, and there are pluses and minuses to doing the MAGR. Certainly the MAGR ends up being employment, but I agree with Jody, though. On the other hand, I do think it is something of a motivator to do the best deal that you can. So we'll see.
Great.
Larry, this actually relates to a question that was asked, which I'd like to answer because it's right on topic for two reasons. One, it's from Louise Nemshoff, who I'd like to say, Louise, great to hear from you. Last time I saw you, I think my hair was fully brown, but she was asking about how these ILFs compare to third-party deals. Obviously, my defense of it depends heavily on it comparing favorably with third-party deals. And I will tell you quite candidly, we modeled them for HBO Max, for example, and I've negotiated these with a number of people, possibly even on this call. We modeled it over similar deals we had made with third parties for similar rights. I mean, we knew we were going to be challenged on it, so we wanted to, when we were trying to get people to agree up front, we wanted to give them the same defense we would have given them in hindsight, which is this deal's as good or better than the deal we would have made had we sold the show to a third party with similar rights, and maybe even with greater reach. So I would argue that the imputed license fee is even better, but I'm not exactly objective. But it's certainly, it won't withstand scrutiny if it isn't consistent with third party deals. So that's kind of how we've measured them. I'm sure Cathy's litigators wouldn't let her give an answer any different than that. But I honestly do believe that.
I 100% agree with you on that one, though. If you'd ask me, that would be the same answer I would give, because we're not going to be able to get it signed, and we're not going to be able to defend it if we didn't go out and look at it. And there was a lot of thought that went into that. So, yeah.
We have another question, and I think we answered this, but I'll let you hit it, from Richard Jefferson. Have any of you dealt with replacing profit participations with a bonus structure that subsidies are implementing? Now, I'm not sure if he's implying that you had a MAGR and then you moved it into a bonus or renegotiated it, or I guess, Kobie, you've probably had a lot more experience in this area than anybody on that, I'm guessing. Maybe I'm wrong.
Our deals, like, if you're coming directly to us, our deals are pretty straightforward, and we have the fees and what I talked about earlier, the premium or the buyout. You only kind of run into these kind of different and unique circumstances if you're acquiring a project that has been set up or produced someplace else. And in that case, depending on if it's some sort of acquisition or some sort, you pay whatever that acquisition price is. And the individuals who did the underlying agreements will have to determine how they're going to split up their profits in that factor. But that's left on the producers and not necessarily us, because we're just acquiring a package and not necessarily trying to individualize the deals.
Right. I think I was going to ask that question with regard to, if someone does a deal and then they come in, and they did the back end based on an MAGR or a different type of definition, and then they go to Netflix and that doesn't exist anymore, and how they're going to determine it would be more based on the license fee, I would suspect. There's questions, two questions regarding MAGRs. Jay Doherty made a comment, I mentioned this earlier, that there's common law. Can we rely on that if it's not specifically in the contract? And then Richard Hege asked, can force majeure be invoked successfully in an option agreement that contains no specific force majeure clause, which I think you would have to rely on a common law approach on that. Have you experienced any of that, or any thoughts on that?
I will say that not in an option agreement, but I did have an agreement where there was not a force majeure provision. So we were looking at the common law. We were looking at the doctrines of impossibility and impracticability and frustration of purpose. And fortunately, I think, given just the circumstances and the of that particular project and what was happening, I think we actually had good arguments under frustration of purpose that delayed performance, that we were able to delay performance, and we were able to come to the table and just renegotiate the whole plan for that particular agreement. I'm not saying that you should rely on that in lieu of force majeure provisions, but it was actually a situation where I think we had good arguments.
Yeah, you could certainly rely on common law in the absence of a provision. Although I will say, I think we have provisions virtually everywhere.
Yeah.
It's really rare that we didn't. I will also say
this was like a one-off kind of thing. I will say it. I'm not aware of another agreement where we had this. At least where it came up.
The truth is that most people, because this force majeure was so widespread and so consistently affecting everyone, I will say with our relationships with the networks, everybody was pretty cordial about it. We didn't really have a lot of fights about what it meant and who gets off the hook. I mean, clearly we couldn't deliver episodes, and nobody was going to hold us in breach, nor was I going to ask them for license fees for episodes I couldn't deliver. So for the most part, people acted fairly honorably. I think on the option agreements, it's a much tougher case. We had provisions usually that said we could suspend. Usually it was capped at 60 or 90 days.
Mm-hmm.
If without that provision, we didn't really rely on it because it's a matter of proof. You have to prove that you couldn't continue developing. If it was a reversion issue, then maybe it's a little easier because you got stuck in the middle of production. But if it's an option period, which is where you usually are, because once you've bought it, the reversions are usually far enough out. So it's a tougher call. We did not really invoke it in our development very often if we didn't have to. And by the way, most of the time we go to them saying, we have an extra 60 days COVID. And they'd say, okay.
Yeah. I think most of us have experienced something like that. In response to the question regarding having a clause or not having a clause, Max Brecker adds, that his understanding is that where there is a force majeure clause, the contract clause basically eliminates the common law principles. I'm not a litigator, so I'm not going to respond to that. We have one other question, and then we can finish up. Is there a permissible way to consider talent's vaccination status before hiring? Are vaccinated actors going to get preferential casting treatment? I think I know the answer to this, but I'm going to let you all address this. I can tell from your face, Jody.
I'm not an employment lawyer, so I'd be really hesitant to answer. But this is fraught with problems because you have all of these vaccination preferences that people are very troubled by. And so I don't see that happening. But I really don't know. It is one of the next big questions we're going to have to face is what do vaccinations mean? Can we demand proof of it? Can we make it a condition of employment? There are people who have, anti-vaccination beliefs. Are we going to prohibit them from working for us? So I can't answer that yet, but I'd be happy to hear what you think about it.
Well,
it's a great question because it doesn't just apply to us. Like this is a larger question about any employment relationship going forward. And I know obviously, you have to have children to get vaccinated to go to public schools and things of that nature. I don't know if this goes as far as like making like a governmental requirement to get a vaccine. So like unless that occurs, I don't think, as employers, and again, this is not my space. It'd be very difficult to require this unless there is some true kind of like employment related issue, like if you work in the medical industry or something to that effect, where they sometimes require certain flu shots and vaccinations periodically.
Well, and I agree with you both. I mean, it's just not something that I believe. I think they would call it discriminatory in many ways. We leave it to the labor lawyers who are going to have to fight that one out when it comes up. And I think the guilds would have a problem with it as well. I think they're looking at, they're taking as many precautions as they can that they believe within the scope of their ability, and to require their signatories to do that. But when you get into personal beliefs and such, I think you're going to be running into problems. In closing, I want to ask if any of you have any final comments that you'd like to make. Start with from my viewpoint, left to right, as I'm seeing you, Jody.
No, other than, we're all working towards the same goal here, which is to get as many shows running as safely as possible. That really, there's no ulterior motive here other than to keep everyone safe. That's our business interest. So, as a studio, and I will speak for the studio here, I think we've done a great job so far. We obviously count very much on the help of all of your clients and appreciate it. I think it's been a tough road, but we've gotten this far. So that's my final thought.
Cathy, anything?
I'm not sure I could say it any better than that, but yeah, I mean, really, I think just on the COVID piece, that is absolutely the goal, 100%. And people work very, very hard on that. On the OTT piece, I will just say that something that, like we've said, that because it keeps evolving, because it keeps changing, I think it's what makes my job really interesting and really engaging. So it'll be interesting to see how we're thinking about it again in a year.
Great. Anything to add, Kobie?
I think the one thing that if we can kind of carry this even beyond like the COVID period, the way that the industry kind of came together to kind of figure this out, and we had to put a lot of hats on and we had to be collaborative to kind of get this done. If we can kind of keep that spirit going, like that's the one thing I want my kids to go back to school, and eventually I want to go back into the office. But the one thing that we can keep is kind of like that sense of working together to figure out these issues and these problems in a very creative and a collaborative way. If we can keep that's all I can ask for.
Okay, well, I want to thank you all very much for agreeing to participate. I'm appreciative, as is the entertainment law section. And that concludes the program. Thank you all again.
Thanks, Larry. Good to see you, Kobie, Cathy.
Likewise.
Good to see you. Thank you, Larry.
Thank you all. It's good to see you all.
A good one.